Hi, I'm firearms attorney Gilbert Ambler, and today we are going to talk about 5 things that you should know about the ATF's notice of proposed rulemaking on who is engaged in the business of selling firearms, because it's going to affect a lot more of you than you might think. All right, now, this is all set up. The whole setup for the ATF's ability to do this came from the Biden administration and the Bipartisan Safer Communities Act. Because in the Bipartisan Safer Communities Act, there was a wording change in the law on who was engaged in the business of selling firearms. That's an important term, because if you are engaged in the business of selling firearms, it subjects you to the federal firearms licensee requirements, meaning all of the licensure and all of the record keeping and all of the costs and expenses and requirements that go along with having a federal firearms license. Okay, it subjects you to ATF oversight. And in the Bipartisan Safer Communities Act, they changed the term who was engaged in the definition of who was engaged in the business from someone who had the principal objective of profit and livelihood to somebody who sold firearms predominantly for profit. And a lot of people, Republicans included, sort of dismissed that change as not a major change, but it set up the ATF to now issue this new rule saying this is a new legal term and we're going to help provide guidance on how we understand and interpret it. Before we dive into this subject, if you have not yet hit that subscribe button, go ahead, hit subscribe for us, like, comment, share, tell your friends about this channel. That way you and your friends can keep getting this important Second Amendment related content. All right, the first thing we need to understand about this proposed rule is that it provides several presumptions for who is engaged in the business and operating predominantly to make a profit. Okay, these are civil presumptions, meaning the ATF says these basically are intended to apply in civil proceedings like FFL proceedings. So if they deny somebody a federal firearms license or they go to revoke a federal firearms license, those are civil proceedings. These are not, according to the ATF, designed to apply in criminal court, although the ATF says that they might be helpful in criminal court. Okay, so not designed, but might be helpful definitions for criminal court. And these presumptions, some of them are probably fairly common sense. You know, if you have a business space and you get a business license from the township or your state to operate a business where you're selling firearms, then you are probably engaged in the business. So some of that makes sense. However, the ATF starts to reach a little bit. And this reach really starts, one of the biggest places you see this reach is on page 43 of the Notice of Proposed Rulemaking. Because on page 43, the ATF says that they're clarifying that you, in fact, don't have to, make a profit in order to be operating predominantly with the intention of making a profit. And what they're doing is they're taking a prior bit of law that said you might not be operating for the purposes of making a profit if your primary motive is criminal or to promote terrorism. So if you're selling guns for a criminal purpose or to promote terrorism, they didn't have to prove in the past that you were acting to make a profit. They're taking that bit there and they're saying this applies to everyone now. You don't have to, in fact, make a profit in order to be operating with the predominant intent to make a profit. So that's a little bit of trickery that we need to keep an eye on, because that's one of the big problems, I think, with this notice of proposed rulemaking. As for the other presumptions that the ATF talks about, they say things like, if you offer for sale any number of guns, and at the point you offer them for sale, you make it clear that there are additional guns that you would be willing and able to sell, that creates a presumption that you're engaged in the business of selling firearms, such that you need a federal firearms license. Let's talk about how that scenario could play out for just a second. Imagine I live in a location where the state has not outlawed the private sale of firearms. And so my neighbor wants to purchase. He saw an old 1911 I had. I don't shoot it anymore. He's been asking if he could purchase it. So one day I take it down the road and I sell it to my neighbor. And as I'm selling this old 1911 to my neighbor says, you know, you also had that 3030 up there in the closet that I've always loved. Would you ever consider selling that? And I say, yeah, if you come by, I'd sell you that sometime in the future. Guess what? I am now presumptively engaged in the business of selling firearms such that I need a federal firearms license, because I have sold one or more guns and expressed my ability and willingness to sell a future gun. So ATF says that makes me a gun dealer. That's one of the presumptions that you need to know. Another presumption If you spend more money in any given period on firearms than your gross taxable income during that same period, it also creates a presumption. What this really does is this rule really discriminates against people that are good at saving, or even retired folks, people that have saved up funds their whole life, because saved up funds that you already have in your bank account, that's not income. But if you spend more money in any given period than your taxable income, the ATF is going to consider that a presumption that you are engaged in the business of selling guns. Another presumption, if you rent any space for the purpose of selling guns, even if it is one time, so you reserve a corner of your buddy who owns a gun shop, you reserve a corner of his space at a gun show because you've decided to start selling off your collection because you need to put a new roof on your house and it's expensive. Guess what? ATF says you are now engaged in the business presumptively. Additionally, the ATF says if you repetitively, and there's no definition of repetitively, but if you repetitively sell guns in new or like new condition with their packaging, then that's presumptively engaged in the business. New or like new condition? Are you kidding? I try to keep my guns in like new condition. I'm meticulous. I take care of them. I clean them. I make sure they're in good shape. Apparently, if I were to sell them, and we all know that packaging can help the value of a gun. Look at old Colt Pythons. Colt Pythons with their original package in like new condition. If I happen to be a collector of those and sell off more than one of them, sold off two, well, now that's repetitively selling them. Apparently, I'm presumptively engaged in the business according to this ATF proposed rule. Furthermore, if I sell guns within 30 days of obtaining them, so I buy a new gun and repetitively sell that gun, or sell similar guns. So I go to a gun store, I buy a gun, I take it home, I try it out, I don't like it, I decide I'm going to sell it, turn around, try another gun out, also don't like it, and it takes me the third try to find a gun that fits my hand that I actually like. Well, I sold those two prior guns within 30 days of purchasing them. That presumptively means I'm engaged in the business of selling firearms. If I regularly sell firearms of the same make and model, so if I have Glock 19s with consecutive serial numbers, that's a pretty cool find if you ever stumble across it. But if I bought those and then sold them, well, it's two Glock 19s, same make, same model. Although there is a reason that I'm selling two guns of the same make and model, because the consecutive serial numbers are pretty cool to a collector, ATF says presumptively engaged in the business. Interestingly enough, the ATF also says you are presumptively conducting this business for the predominant motive of obtaining profit if you have any spreadsheets that might help you track your profits and losses. I don't know about you, but I know an awful lot of people out there keep spreadsheets of their firearms just so that they know who they bought them, who they sold them. Therefore, if an ATF agent ever showed up at their house trying to trace a gun, they would be able to provide reliable information. But apparently that's going to be used against you in the future if this rule goes into effect. All right, so that was a long-winded first thing to know about the rule, but the first thing, it is important, creates a number of new presumptions that can be used in civil court. Second thing you need to know is this is not just about gun shows. A lot of people are saying, oh, this is aimed at shutting down gun shows. It goes far beyond gun shows, and in fact, I don't think it's going to have a major effect on gun shows, since most gun shows that I go to are almost entirely filled up with people that are already federally licensed. This is going to affect the ability of people's willingness to sell a firearm to a loved one, to a coworker, to a neighbor. Those private transactions, it's going to allow the federal government to get their hands into those transactions because it's going to force them through FFLs, because people are going to be afraid of being accused of being engaged in the business without a license if they sell any firearms privately. What this is really about, it's not about shutting down gun shows, it's really about registration. They want to make sure that there is a record of all of those firearms transactions and that you're not selling any firearms to your friends, loved ones, or neighbors that are not being tracked by the government, by the federal government. So I think that's what this is really about. The other big thing, this is going to have a big effect on the ability of 18, 19, or 20-year-olds to possess firearms. And I am aware that there is currently, it appears, a judge in Virginia is going to rule the statute that prevents a federal firearms licensee from selling a handgun to an 18, 19, or 20-year-old. It appears that that is going to be struck down. But if it is not struck down, or if that decision is stayed and then overturned, the problem is Individuals are going to be afraid to privately sell firearms to an 18, 19, or 20-year-old because they might get accused of being engaged in the business. And they're going to say, go to a gun store. And a gun store, legally as an FFL, cannot sell a firearm to an 18, 19, or 20-year-old under current law, unless, of course, that is overturned, which is something that we're hopeful for. But if it's not, going to be a problem for that age bracket. Finally, this is a big departure from how the ATF previously conducted business, because I've done a number of initial inspections with ATF agents in the past, where ATF agents come out and do the initial inspection for somebody who wants to become a federal firearms licensee, wants to get licensed. And one of the things that they typically do is they ask questions to those individuals to make sure that they really intend to engage in the business, that this is going to be a business, not a hobby. This is not just them getting a license so that they can order firearms to their house, that they intend to go into business. They want to know what suppliers have you contacted, things like that. Obviously, a big departure here because we're talking about people potentially selling 2 or 3 guns that are now told they have to have an FFL, not somebody who's been in contact with wholesalers. Third thing that you need to understand about this new rule is that they are concerned with FFLs that are getting revoked accepting the firearms into their private collection. Okay, this has always been a concern for the ATF, that when an FFL has their license revoked, that unless the owner of the FFL has some other prohibition on their ability to possess firearms, the firearms can then go into their personal collection, and from their personal collection can then be sold off. This rule is effectively going to stop the ability of an individual whose license was revoked from being able to accept the firearms at that point into their personal collection and then slowly recouping money from those firearms by selling them off. The ATF says, no, if you want to sell them out of your personal collection, they had to have been in the personal collection at least a year prior to the revocation. So it's effectively going to eliminate that strategy for people to recoup some of their funds. And of course, this is a big problem with FFL revocations through the roof, because those FFLs that are getting revoked for minor paperwork errors, that is their livelihood, and they are not going to be able to effectively recoup any funds from their business after it is closed by the ATF for something that might be as innocuous as a couple of paperwork errors. Fourth big concern I see with this rule is the huge potential for disparate enforcement. And when I say disparate enforcement, I mean, how in the world is the ATF going to pick and choose who they go after under this rule? It seems to me that a lot of the things they're talking about, whether you have spreadsheets, whether you have expressed a willingness to sell firearms in the future, these are things that they would probably either need your admissions or a warrant to find out about. Absent that, they might use confidential informants to try to get some of this information. But how are they going to pick and choose their targets? I am very concerned that because this rule would likely affect so many people in the firearms community, that it's going to lead to a situation where the ATF picks on people that they otherwise want to come after for some reason, and they use this rule as an excuse to come after them for engaging in the business without a license. Final thing you should know about the rule at this stage is it is not yet a final rule. It is a proposed rule, which means you have 90 days from the date of publication to comment on this rule, and you can and you should comment. My advice to you is try to write well-informed comments that are not just rude towards the ATF. Sure, you might want to say rude things to the ATF, but those comments aren't taken seriously. Provide thoughtful comments. Think about what we've talked about in this video. Write a thoughtful comment, because those comments do have an effect. We saw the change in the pistol brace rule based on all of the comments that were received, and that change in the rule is now central to the fight against it. If you enjoyed this content, go ahead, hit like, hit subscribe. Until next time.